So good evening, everyone. Welcome to the Florida Interest Network June 2021 workshop. I am pleased and proud to introduce to you Rebecca Cantor, who I knew back when she was Rebecca Amster. Rebecca is one of those unicorns that is both a JD and an LMFT, and has done many things in her legal life and clinical life. So I'm sure she'll tell us a little bit about that. But we were chatting one day and said, wouldn't it be cool to do a workshop where we put the participants on the stand and made them a witness in a court case? And we bounced that around for a little while. And then we decided, well, really, we probably need a preliminary workshop that allows people to learn some of the language, get some of the terminology and those kinds of things. So tonight is that workshop. So this is, you've been served, now what? Pre-subpoena work. We have lots of lovely handouts. For some reason, the link in Facebook didn't want to work, Rebecca. So I'll try to figure out a way to put it in where it can be in this recording so people can take a look at it. But anyway, so I'm happy to have you all here. And without further ado, oh wait, she put it in there for us. So if you want to capture that out of the chat and grab that for the documents, that would be terrific. And I will leave you to take it over. Thanks.
Well, thank you so much. I'm so pleased to be here presenting this. Part of the thought process behind why we wanted to create this workshop was because I had observed to Dr. Schooley that on the whole, it seems that therapists who serve really critical roles for a lot of folks in the context of their cases, their litigation cases, really don't know what to do when the process server comes knocking on their door and are remarkably intimidated by the process of litigation, the process of being subpoenaed or being deposed or being a witness on the witness stand. And I really wanted to bring some education around that, clear up some fears, misconceptions, and sort of help explain the process to people so that truly at the end of the day, we all kind of work together as professionals. It's true that I am an attorney and a marriage and family therapist, and there's about 3 of us that I know of in the great state of Florida. There's one in Broward. That's Lisa, who is a graduate of the NSU program SMI. I'm down here in Dade. And then there's a lovely lady, Alyssa Pearl, I think is her name, and she's up in Palm Beach County. So there's like 3 of us.
And hey, I knew a 4th, Eric Epstein. He was in Broward. So now there's 4. Very exciting.
So I've been a practicing attorney for, oh gosh, 21 years. I can't believe I swore into the Florida bar when I was 3 years old, obviously. And so, and I worked at Legal Aid first, and I represented victims of domestic violence, and then ultimately went and got my MFT post JD, and have always been very centered in the field of family law. And the way I describe what I do to everyone that makes sense is that I'm a child advocate. So that's my lane. I don't help divorcing parties with any of their monetary issues. That's not something that I'm particularly skilled at. I can do it, but it certainly doesn't thrill me very much. But all issues around children fascinate me. And all issues around how parents parent their children, certainly subsequent to a breakup, also interest me a great deal. So that's kind of the lane that I'm in. And I love it. And because I'm an MFT as well as an attorney, I tell everyone I speak 2 languages, because I speak lawyer, which is the language I'm going to decode for everyone tonight, but I also speak therapist. And that helps the lawyers a lot because they'll get some report or they'll get some diagnosis or they'll get something and they'll call me and they'll say, what does this mean? And I can help decode that for them. So that makes me a useful tool for everyone. So what I did was I created, I invented a case that we've been working on as therapists. So I'm going to introduce the case, and then I'm going to talk about sort of the technical stuff that goes along with the case. But this is a nice way to sort of think about what you would have done, or how you handle it, or who are you protecting, and who's your client, and a lot of those sticky ethical issues. And then we'll talk about how they sort of interact and intersect with the legal issues, because ethics and legal stuff aren't always the same thing by any stretch, right? Okay, so here's our case summary. It's a true story. Every fact that is in this, every quote that is in this is in fact 100% true. I pulled it, I fact checked it. I am not making this up, except for the fact that we are not the therapists. So this is the case of Kim Kardashian, who's divorcing Kanye West. They have 4 children: North, Saint, Chicago, and Psalm. And the children are age 7 and 5, 2 and 1. We have been seeing the 7-year-old and the 5-year-old in our clinical practice. The children were brought by their mom, Kim, who wants to make sure the children weren't suffering any ill effects from their father's absence from the home. In our pretend world, the children have had 15 sessions since February of 2020. They started with us in real life. Kim does have a home here in Miami, Florida. And then they moved to virtual sessions as the pandemic took place. 10 of them, Kim has brought the children. Of the 15 sessions, 10 of them, Kim has brought the children. 3 have been with their Aunt Courtney and Grandma Chris, and 2 have been with their nanny. And then during the course of treatment, you've learned the following information. Kim lives in Los Angeles most of the time. She's 40. She's also has a home here in Miami. This is her 3rd marriage. Kanye is 44. He permanently moved out of the LA home in May of 2020. He lives full-time in Wyoming now, and he has not seen his children since he moved out. In February of 2021, Kim filed for a divorce. They are worth approximately $2.1 billion with a B dollars, but there's a prenup. So they're really probably not going to litigate finances, which means they're probably just going to litigate children's issues, custody. And we'll talk about what custody is in a little bit. Kim has a very famous high-end lawyer. Kim is represented by the same person that represented Johnny Depp and Angelina Jolie in their divorces. Angelina Jolie's divorce with respect to children's issues is ongoing. She's appealing the most recent court ruling. So here are contributing factors. Kanye suffered a very public mental health breakdown, which included a run for president in the 2020 campaign cycle. He publicly acknowledged that he was diagnosed with bipolar disorder and publicly stated that he does not take any of his prescribed medication. It interferes with his artistry. For a long time, Kim was very supportive of that, but ultimately stopped being supportive when his experience of his mental health really sort of disintegrated in the public eye. And so then she really did want him to get on medication, and that wasn't something he was willing to do. While he was experiencing his mental health breakdown, he stated that slavery was a choice. He called Kim and her family white supremacists, and stated at a campaign rally that Kim wanted to abort her pregnancy when she was pregnant with North. He also heavily criticized Kim's appearance as she grew more fashion forward and sexy. He told her that her dress choice for the 2019 Met Gala was too sexy. It affected his soul and spirit. Kim acknowledges that she's a lot of anxiety around how she appears based on how Kanye responded to how she appears. A lot of that stuff got twisted together. Kanye, during the course of the last few years, founded his own evangelical church, and religion became a splitting point for the parties. Kanye was literally preaching conservative values on premarital sex and a pro-life stance, while Kim was literally posing nude and supporting Planned Parenthood. So very divergent religious views. Ultimately, and the reason why Kim filed for divorce was that she's trying to protect the kids from Kanye's mental health struggles, both private and public, right? There's so much more that went on behind the scenes, as it were, than what was forward. Let's see, next page. I've got the same thing, but in hard copy. Kim cites the distance between the two homes as a contributing factor to the divorce. Kanye lives full-time in Wyoming. Kim lives part-time in Miami, part-time in Los Angeles. And that distance made it really hard to do the little things. Kim lives a life of tremendous extravagance, publicly and privately, and she has all of the big ticket items that anyone would want, all of the tangible things that any person would want, but she doesn't have the little things. And what she really wanted and what she found she was missing with her marriage and Kanye was the little things, right? Somebody that she could work out with, or somebody that they could watch television shows together. And he doesn't do any of those things with her, nor did he want to. Kim is now seeing an individual therapist. Her goal in therapy is complete happiness. She states, I mean, I have my kids, but am I just going to sit here and think my kids fulfill me and I'm good? She reports feeling numb and tired of having emotional breakdowns. Kim talked about her worries about the children's behavior. She really wanted to make sure that they were protected, that they were bearing the separation from their father and any ongoing challenges they might have faced, maybe seeing something in the public eye, and certainly the children have very public parents, and she wanted to make sure that they were protected from that. All of the behaviors that we've observed as a therapist were very consistent and typical of developmental phases that children go through, as opposed to being related to their father's absence. So temper tantrums over not getting the toy, very typical behavior, or problem sharing, again, very typical behavior. You as the clinician have no clinical concerns with respect to the children at this time. So that's great, but now they're getting divorced. And so the question becomes, now what? Right? Because we know that they're going to litigate their case. And what are you exposed to? Right? If they're going to litigate about the custody of their children and you have some information, chances are pretty good when you have a case where the parties have essentially more money than God, you're going to get called in. And one of the things we're going to talk about next time in July, so I'll preview that, is what you can do to protect yourself in the event that you may be called in for litigation, what you can do at the super front end in terms of what your agreement for services might look like, how to identify a particularly litigious case. Sometimes there are some big red flags and you may decide you would not like to be involved in litigation. But sometimes you find yourself dragged into litigation despite your best efforts. And so, Annalyn, without sharing the screen, I'm just going to talk about the next document because I think that might be a little bit more helpful. All of these documents, everything I'm talking about, of course, you have provided to you in the Dropbox link. We will email them to you if it doesn't work to open the Dropbox link. But I wanted to talk about sort of how the initial process works that you don't know about, the behind the scenes part about subpoenas. So Kim's got a lawyer, and we're going to pretend for a minute that Kanye's got a lawyer. And Kanye's lawyer's got some questions for you, the children's therapist. And he would like to take your deposition. But they can't do that immediately in a family law case. You have to let the other side know that you want to take a deposition. So there's a document in the Dropbox called Subpoena Redacted. This is a real subpoena in a real case that I'm really on right now. And it was a subpoena sent to a medical doctor because that's a case where there's a question of whether or not someone is using drugs and has a drug addiction. But it looks substantially the same as something that you might receive as a therapist. But the first thing that happens is actually the first page, which is a notice of intent to subpoena documents from a non-party. You, the therapist, are always a non-party. You are not the party. Unless you're actually being sued, unless your name actually appears at the top of the document, you are a non-party. So are the children of their parents' divorce proceedings. They are non-parties. And it matters because the rules are different for non-parties than they are for parties. So if an attorney wants to get some documents or ask some questions of a non-party, they need to let the other side know that that's something they want to do. And so they file something called a notice of intent to subpoena, which is essentially, hi, I would like to get these documents from this person over here. Here's your opportunity to object, because maybe you don't want me to do that, right? And we like to play fair. And the other side has 10 days to object. But not only do you file the notice of intent, you file a copy of what you intend to serve. And when you ultimately serve the subpoena, you have to serve the identical thing. That matters. And we'll talk about why that matters in a little bit. So that's the first thing that happens. And in this particular case, that I have this particular document, in fact, the other side did object to the intent. We had to have a hearing on it. The judge had to make a ruling, and then the judge ultimately ruled, yes, the subpoena may be issued. And the judge ruled that the subpoena may be issued because both parents are alleging that each of them has an opiate addiction. And both parents are alleging that each of them have seen this particular doctor. But only one parent asked for documents as it relates to the other, which is sort of an interesting twist, right? Because lawyers can choose to litigate how they want to litigate. They get to choose how to run their cases. Us as the helping professionals, therapists, and otherwise, we don't tell people how to litigate. They're going to do what they want to do. So in this case, they filed a notice of intent. Ultimately, the subpoena was served. And the second page of the document, actually the third page of the document, because the second page is the notice of the issuance of the subpoena. And then the third page is the return of service. So here's what happens, right? You're sitting in your office doing your thing, seeing a client or doing your paperwork or whatever it is, and there's a knock on the door and a process server arrives. Don't ever, in my opinion, fuss at the process server. He or she is just doing their job. Their job is to deliver a piece of paper. They don't know, they don't care, they're not interested in whether or not it's legal, whether or not it's right, whether or not the other side's a jerk. If it's a lawyer, I guarantee you the other side's a jerk. Lawyers are jerks as a group, right? That's kind of like if there was a DSM subheading for jerk, lawyer would come under that column. That's us. Okay. So after you're served, right, say thank you very much to the process server who's just doing their job. And once you've been served, the process server files this little return of service. So that's what happens. And that's what happens on the court side. And that little return of service document gets filed in the court file so the judge knows that you got served. Okay, you got served. This is the moment when most people panic, right? Don't panic. All is not lost. There are many, many things you can do, many choices you have, and ways to consider how you want to act professionally. But now you've been served. And then the next page, right, is the subpoena. This is a subpoena ducis tecum without deposition. Oh, that's fancy language. What does it mean? It means they want records. Right? Subpoena ducis tecum by itself means they want to ask you questions. Subpoena ducis tecum without deposition means they want documents. They want records. Again, that matters, right? Because depending on what records you may or may not choose to produce, changes when you might have to produce them or how you might have to produce them, and changes maybe your deadline. So anyway, you get this stinking thing. So it says here, right, you're commanded to appear on Friday, April 23rd at 9:30 in the morning. Well, if Friday, April 23rd at 9:30 in the morning is not convenient for you, then you can call the lawyer and say, listen, that's not convenient for me. Maybe the lawyer wants 10 years worth of records, 5 years of which you have in storage in another county, in another state, because you worked somewhere else. And you do not have enough time between now and this deadline to go get them the documents. You call the lawyer and you say, can't do it by then. Not going to happen. I need an extension. And the lawyer, if they're a decent person, is going to say, okay. Or it's like one page. It's one stupid thing, right? That they signed in and they never actually attended, right? And maybe it's not a record that you're really worried about protecting any confidence. Then, right, you don't need to show up on April 23rd at 9:30 in the morning. You call the lawyer and you say, hi, have your stuff. Can I email it to you tomorrow? And then I don't have to show up. And the lawyer's going to say, sure. Right? Because they just want the stuff. They don't want to show up at April 23rd at 9:30 in the morning either. They just want the documents emailed to them in their inbox. So already don't panic. So what do you do when you get the subpoena ducis tecum without deposition, right? Then you read the instructions. I want everyone to please note that the instructions are 1, 2, 3 pages long. Right? It's 3 pages worth of instructions. You should read them. It's a lot of legalese. It's not overly challenging. It mostly talks about who needs to produce it or how it needs to be produced. And then finally, on the second to last page, it says documents to be produced. This thing only asks for 4 things. It's only 4 items. So this is a 9-page document with 4 requests. Welcome to attorneys. We are jerks. We do this on purpose, right? So you look through, bless you. So you look through those things and you may decide that they're totally confidential. And I'm not producing any of that. We'll talk about that a little bit later. You may decide, oh, yeah, this is reasonable. I can do this. No, not a problem. If you decide that ethically, morally, all of those kinds of things, yeah, these are documents I can totally produce, you produce them. And then the very, very last page, they provided for you, because at least attorneys like it to make it easy, the certification that you've actually produced the stinking thing. So you fill it out, you get a notary to sign it. You don't have to worry about what that looks like. You don't have to worry about formatting. You just, and this is a page that can be totally handwritten. Okay, so now we've sort of blown the lid off what a subpoena looks like. Why is it not scary? It's just a piece of paper, right? We don't have to be afraid of it. I should tell you, actually, that when I started working at Legal Aid in the year 2000 as a baby attorney, remember I was only 5 years old when I swore into the Florida bar, I did not know how to produce a subpoena. I didn't know what, I knew the concept. I had studied it. I had taken a bar exam about it. I understood what it was for and what I was supposed to do with it and the information I was going to try to receive from it, but I didn't know how to write one. I have been practicing law for 21 years. I do not know how to write a subpoena. I have a paralegal. My paralegal knows how to write a subpoena. I call my paralegal and say, hey, Yaz, I need a subpoena to Dr. So-and-so and I want the following documents. Yaz does all the work. Yaz tells me where to sign. And I assure you that 98% of any attorney and any subpoena you ever receive is in the same place that I'm in. Their paralegal did it and the attorney signed it. Because, yeah, we know what we want to do. We just don't know quite how to get there. Okay, so let's talk about some of the rules around subpoenas, because once you get the stinking document, then you have to decide what you're going to do about it. And so the next thing that I've given you is, oh, the house line is ringing. Someone's going to tell me that my car may be out of warranty. Is everybody else getting that phone call at around dinner time? Probably. So, okay, so here we are looking at the subpoena rules. There are 2 sets of subpoena rules, well, 3 or 4 actually, in Florida. The first set of subpoena rules always start with the number 1 dot something. Oh, no, I might qualify for a bigger credit limit. That's what the machine is telling me. So all of the Florida rules of civil procedure, which are the basic rules around subpoenas, start with the number 1. And then any case in Florida that involves families, all of those numbers start with 12, because that's the family rules of civil procedure, which essentially mirror the Florida rules of civil procedure. And so we're going to talk mostly about civil stuff. The rules around criminal procedure are a little bit different. Chances are pretty good that this group of folks will be working on civil issues. So when we think about rules and statutes, it's really important for you all to keep one thing in mind that I learned in law school that I think is remarkably useful. And that is that all rules, all regulations, all statutes can be used as either a sword or as a shield. And so the very first thing you want to look for, having been served with a deposition or served with a subpoena, is your shield. And the very first part of your shield is going to be located right in the first paragraph, 1.351A, right? The request and the scope, a party may seek inspection, etc., etc. The second sentence is, this rule provides the exclusive procedure for obtaining documents or things by subpoena from non-parties without deposing the custodian or other person in possession of the documents. What does that mean? That means that if a lawyer sends you a letter saying, I need the records, or if a lawyer picks up the phone and calls you and says, I need the records, or sends you an email and says, I need the records, or in any other way tries to get records from you that does not involve the formal service of a subpoena, you don't have to produce a thing. This is the exclusive way for somebody to get these documents. That's it. This is it. So if you're not getting if the process server has not knocked on your front door, you don't have to turn over a danged thing. And if they give you a problem about it, you can write a very professional looking email and saying, please refer to Florida Rule of Civil Procedure 1.351. If you would like documents, you may certainly serve me with a subpoena. Here is the address where you may serve me. That's how you do it. Don't let the lawyers rattle your cages. Let them rattle all you want. They're not going to get what they want unless they do the actual things they're supposed to do. Okay. Further down, you're going to see some day requirements, right? You have to, the lawyers have to let each other know 10 days ahead of time. They have to give each other 15 days to respond. And then the other thing I want you to look at on the first page is right there in section C. Scroll just a little bit further down for me, please, Dr. Schooley. Yes, good. So just at the bottom half of that paragraph, it says, the person upon whom the subpoena is served may condition the preparation of copies on the payment in advance of the reasonable cost of preparing the copies. That's not just 10 cents per page, but also the kind of time it's going to take for you to find the file, because what if it's in storage? And then also the kind of time it's going to take for you to do the copies. And if you need to do some redaction, all of those things are reasonable costs. And you don't have to do a single thing until you've been paid. So you can send a bill ahead of time and say, dear attorney, I anticipate it will cost about $150 for me to do all this stuff for you. Kindly pay me the $150 and then I'll get you your stuff. That's how that works. Nearly 7 o'clock, and I think the UPS guy is at my front door again, or Amazon. I'm not sure which. Okay. So, and then the very last line on that first page, which goes on to the next one, again, another shield. If the person upon whom the subpoena is served objects at any time before the production of documents or things, the documents or things shall not be produced under this rule. If you object, the documents shall not be produced. You have a lot of shields here. You are not without protection. Do you need a lawyer to object? Absolutely not. Absolutely not. All you have to do is let the other party know, or the other attorney know. And if there's two attorneys, tell them both, I'm objecting to this. It's not appropriate. It's confidential. It's 15 years ago. I don't have any of that stuff anymore. Right? I can't help you. You can object. And once you object, you don't have to do any of it. So remember that thing is at April 23rd at 9:30? Nope, you've objected. You don't have to do it as long as you let the other side know what's going on. Okay. Let me move a little bit further on here. The rest of this document, here we go. The rest of this document, again, is going to mirror, I've given you some of the same sections under 12, which is the family law rules. Again, very similar, if not identical, to the basic civil rules. Yeah, there's a couple other things I want to point out to you with respect to shields. So if you look at, you might have to scroll through a little bit, Dr. Schooley. I'm looking at 12.310, depositions upon oral examination, which is, and that's that's at the top of the page. It's 12.310. Let's see if you find it. You're almost there. Nope. 12.310.
Yeah, this is 1.410.
I want 12.3, which is after 12.4, of course. Keep going. A little bit further down.
It's after. All right, I assumed it was before. Sorry.
It's okay. Lawyers can't count.
Okay.
Also, like so while you're finding 12.310, true story. My first day of law school, I'm sitting in my very first class, torts class, and our professor stands up in front of all of us and looks down his nose at all of us and says, "You're all here because you can't do math and you hate blood." And we all looked around at each other and kind of thought, yeah, well, that's true. I can't do math and I hate blood. That's why I'm in law school. Here I am. So a little bit further down, Dr. Schooley, 12.310.
Which I believe is up. I believe I have that up.
Oh, no, you only think you do. Keep going. It's going to be at the very top of the page.
Interesting. I have 12.310B procedure.
Yeah, well, so 12.351 is referencing 12.310. It's at the top of a fresh page. There it is. 12.
Okay, there we go.
Okay, so statute reading is like impossible. Again, we can't count. We don't do anything in order. It doesn't make any sense. Welcome to the law. But there's another really important shield for you in here. Sort of in the center of that page. It's 12.3102A. If a party shows that when they're served with notice under this subdivision, that party was unable through the exercise of diligence to obtain counsel to represent the party at the taking of the deposition may not be used against that party. There's a little bit of wiggle room here. You're not technically a party as the non-party witness. However, this is going to give you some protection against questions of malpractice. And this is going to give you some protection around questions of if you're going to be asked or a complaint is filed against you against the boards, right? Because if a deposition was taken and you've given some information that makes you look bad, it can't be used against you so long as you show that you tried to get a lawyer and you couldn't because time ran out or you had to be deposed on such and such date and time. So again, another shield for you there. At the bottom of the page, right, Rule 12.351 provides the exclusive procedure for obtaining documents or things by subpoena from non-parties. So again, if the lawyers are not following the rules, they don't get to have the things they want. I always like to tell lawyers, it's nice to want things. You're not getting the document you want. You didn't follow the rules. That isn't how it works, right? Okay. So that's sort of what I wanted to share around the procedural piece of being subpoenaed. Being subpoenaed for a deposition is a similar, a lot of that was about documents. Being subpoenaed for a deposition is a similar process, similar rules. That at that point, they may want to be asking you questions. I often think of depositions as a fishing expedition. It is a truism that when you're in trial, a lawyer should not ask any questions they don't already know the answers to. However, at a deposition, lawyers don't know the answers to their questions. This is their opportunity to find them out. If a judge orders you, or if you decide that you will submit to the taking of a deposition, then you don't have to go at the date and the time they make you do it, right? It says April 23rd at 9:30. If that's inconvenient, then it is incumbent upon you to call the lawyer and say, I would like a different date and time, please. How about April 24th at 10? How about April 23rd at 2? How about April 22nd? Anytime. Put it in writing, because later on, if there's a question that you didn't go to the deposition, you have in writing, yeah, I told them I couldn't make it at that date and time. And then you're safe. Then you're safe because you tried to accommodate the lawyer. You were super professional, you were kind, you were considerate, you gave other options, and they didn't follow it. That's on them. That'll never be on you. Okay. So the next thing I want to talk about a little bit is the Florida statutes, which is a little bit more broad, but it begins to move us into the question of confidentiality, which is always the big question when somebody wants documents from a therapist or somebody wants to ask questions of a therapist, right? We have a duty as therapists to protect the confidentiality of our clients. And that's always our big moral, ethical responsibility, and sometimes a quagmire, right? There are always questions about when do you do that? How do you do that? And in general, the policy of Florida is to protect therapists. And I really wanted to point out some statutes that provided that for you, again, so you can see your shields, so you can see what you can hide behind. So, Annalyn, you do not have to do a share screen. For those of you who are moving through the Dropbox, this is the Florida statute section, just so you kind of know where we are. And I'm just going to go over these a little bit quickly. First of all, in Chapter 61 is our divorce statute in Florida. Let me back up and talk about those for a second. Chapter 61 is our divorce statute. Chapter 741 is our domestic violence statute. Chapter 39 is I call it the DCF statute, which sometimes you hear about children being removed for abuse, abandonment, or neglect. You're hanging out in chapter 39 land. Chapter 728 is paternity. Chapter 63 is child support. So I just kind of want you to know those are your broad terms. So the first statute that I'm referring to here is Chapter 61. And specifically, I'm looking at Chapter 61.122. Again, lawyers, we don't know how to count, right? So it occurs way at the top of the statute. But this is about when a parenting plan is created. A parenting plan is about time sharing, which is about where the children go on what days of the week, whether it's a summer time sharing. We used to call it visitation. Now we call it parenting plan. And oftentimes psychologists, which are MFTs, MHCs, psychologists, psychiatrists, we all fall into this category, are asked to make a recommendation as to parenting plans. And there is a presumption of our good faith. And there's an assumption that we have done the right and professional thing. It is the policy of Florida that psychologists are doing the right and the professional thing. And that's where you start from. And that's the assumption you make. You don't assume that psychologists and therapists are, taking a side or being untoward or using weird practices or unregulated practices, right? There's an assumption that we are all doing our very best at all the time. And in subsection 4, it says that if a legal action is somehow taken against you as the therapist, and you as the therapist win that legal action, the other side has to pay all your fees. All of them. Right? It's called the prevailing party clause. So there's a shield. There's a presumption that you did the right thing. And if you win, which there's a presumption that you'll win because there's a presumption you did the right thing, the other side has to pay all your fees. So you have some protection there, just as a basic policy. The next statute that I cite to is statute 61125. That's actually part of our parent coordination statute. And now we're beginning to talk about confidentiality, because parent coordination is a confidential process. Interesting statutory history. As the parenting coordination statute was written, and the reason there's a lot of teeth around confidentiality here is because as it was drafted, the drafters of the statute presumed that the only people doing parent coordination would be therapists, licensed clinical therapists, MFTs, LMHCs, psychologists and psychiatrists, and pastors. It was not until the subsequent passing of the statute that lawyers were included. And the rules about confidentiality for attorneys are a little bit different than the rules of confidentiality for therapists. And this statute very clearly outlines the rules of confidentiality that we are much, much more familiar with as practitioners of therapy. Again, I really want to point out to you that there are some more shields for you. So there's very specific, so the statute basically says everything is confidential except for these few items. So if the thing that they're asking you to talk about is not included in items A through K, it's confidential. The umbrella is big, the exceptions are small. And the last few ones are really, again, shields to protect you. Letter I, we all know this. We're mandatory reporters. If you hear allegations of abuse, abandonment, or neglect, or domestic violence under Chapter 741, which is our domestic violence statute, under Chapter 39, or under Chapter 825, which is about elder abuse, we are required to report. Really important for us to remember as practitioners, you don't have to know that abuse is happening. You have to suspect it. If you suspect it, you must call it in. You do not need to be the finder of fact. You are acting in good faith. You are protected. If you need to put it in, you need to put it in. If you need to make the call, you need to make the call. The number is 1-800-96-ABUSE. 98 abuse.
96.
Okay. 96. I was right. I am that old. The number is 1-800-96-ABUSE. Okay. The other two shields are right here in J and K. The other two of the other reasons why you can break confidentiality is to protect yourself, is to prove that you did not engage in any professional misconduct. Again, to protect yourself. Those are good shields to have. I included this little thing about child support because I think it's interesting, because it gives us as practitioners some insight into how strongly the state of Florida feels about the need for people to pay their child support obligations. This is a global umbrella rule that if somebody is not paying their child support obligation, 61.13 is the entire child support statute, which is really, really, really long, and it falls in the middle of the divorce statute. But 6113 talks about child support, and right at the top, 6113.015, right at the top, the statute says that if somebody is not paying their child support as ordered by the court, their license can be suspended or denied, which includes our professional licenses. All professional licenses are included in this statute. I just want us to know and keep in mind that, in fact, the policy of Florida is to prioritize children. And that's part of what we do. And when we work with children, we are helping to prioritize them and keep them safe. And it is the policy of Florida that children come first. And it's our obligation to protect them. And anytime you're trying to act in a child's best interest or trying to protect a child's best interests, you will be supported by the courts. And I just want you to be aware of that. What else do I have? All right, so 6120. If you're thinking about getting yourself involved in the family court system in any way, there's places for you to do it. Parent coordinator comes to mind. Guardian ad litem might be something you do. And here's the next one that you can do. So I'm just bringing it to your attention, is social investigation, which is different from a guardian ad litem sort of acting in the child's best interest. A social investigation makes a real specific recommendation as to where the child should live and how often they should see their parent. Sometimes involves the administration of some testing. And under 6120.2, marriage and family therapists are fully qualified to do social investigations. So if you're thinking about expanding your practice or doing something in specific with family law, an opportunity is absolutely involved here. Adding MFTs is a relatively recent addition to the statute. And I wanted you to know that if you're an MFT, you're now in the swimming pool with all the other folks. And then 61404, again, is about confidentiality. And it's about guardians ad litem, which absolutely you can do as MFTs. You can serve as a guardian ad litem, and you may be asked to do so, whether that's a Chapter 39 case or a divorce case or a paternity case. And again, you get to be confidential. You get to keep everything confidential. You get to maintain the confidentiality. So this is sort of an interesting thing that happens. Confidential documents get produced around children all the time, whether a child is seeing a therapist individually, and so there's some confidential information there, whether DCF has conducted an investigation and there's some confidential information there, whether the child has seen a pediatrician and there's some confidential information there. You as the guardian get access to all of that confidential information. However, the confidentiality then passes to you, and you are required to keep all of that information confidential. So you get access to it all. You don't need to worry about waivers or notices or signing releases. Right? Once you're appointed as the guardian, the order appointing you gives you access to all of that confidential information. And the reason why is because 61404 passes the duty of confidentiality over to you as the guardian when you put on your guardian hat. And then one of the final shields we'll talk about, 61405, you're immune. You are immune from any liability, civil or criminal. Blanket immunity. There it is, right there in the statute. So that's a nice place to be as a guardian because you're protected. It's a really nice place to be. Okay, where are we on time? 6:55. Here's what I'd like to do. I'd like to take a 5-minute break because I'm about halfway through. And this seems like a good breaking point. While we take our 5-minute break, if anyone wants to put some questions in the chat, you're welcome to do so, of course. At the end, if we have time left, I will answer any questions. And for as long as Dr. Schooley keeps the Zoom open, I'll hang around and answer more questions even after 8 o'clock or until Dr. Schooley falls asleep, whichever comes first. She may fall asleep at 8:05, I don't know. So anyway, here's your 5-minute break. I'm gonna stay right here, but here's your 5-minute break. I'm gonna take a lot of coffee, but it's sitting here. Please put your questions in the chat.
And we're back.
Okay, so now we're moving into sort of questions around confidentiality. And I came across this slide and I think it's fabulous because I can teach you all of the rules around HIPAA in one slide. All you need. This is it. And it's super easy. So let's put the slide up. And we're going to do HIPAA in one slide, right? HIPAA versus HIPAA. So the one on the left is the one you are probably familiar with. It's the Health Insurance Portability and Accountability Act, which is what everyone talks about when they want to talk about it's confidential because of HIPAA. But everybody misspells it and thinks It's the Health Information Privacy Protection Act, HIPAA, with 2 P's. That's the one on the right. So let's compare and contrast them, shall we? The one on the left, it protects health coverage for people who change jobs. Yes, that's correct. Sometimes we call that COBRA coverage. The one on the left requires medical providers to give patients access to their personal health information. Yes, absolutely. That's required under HIPAA with 2 A's. Number 3, requires medical providers to protect the privacy of health information. Oh, that's really, really, really important. That's critical. Requires medical providers to protect the privacy of health information. Look at that. HIPAA and HIPAA require medical providers to protect the privacy. Does it require schools to protect the privacy? No. Does it require parents to protect the privacy? No. Does it require employers to protect privacy? No. Medical providers. Are we as therapists medical providers? Yes. So we are required to protect medical information, right? Health information of our clients. Does HIPAA prohibit stores and restaurants from asking for proof of vaccination? The one on the left does not. The one on the right does. Does it prohibit stores and restaurants from requiring you to wear a mask? The one on the left does not prohibit a store from doing that, but the one on the right does. The one on the left prohibits anyone from asking you for any health information for any reason. The one on the left does not, but the one on the right does. So here's the important distinction. Is it a real law? The one on the left is. The one on the right is totally made up, does not exist, is not a thing. If somebody is telling you about HIPAA with 2 P's, they are wrong. If you're writing about HIPAA with 2 P's, make sure that you correct and write about HIPAA with 2 A's. And HIPAA with 2 A's is just about medical providers being required to protect their patients' health information. That's it. That's where HIPAA works. Has nothing to do with restaurants, has nothing to do with employers, has nothing to do with schools, none of it. Certainly has nothing to do with vaccinations or masking requirements or prohibitions against them. Nope. The one on the left is the one that applies to you. The one on the right does not exist. That's all you need to know. Look, HIPAA in one slide. Glad I cleared that up. Okay. So let's talk some more about your confidentiality requirements as a therapist. Isn't that a nice slide? Everyone can keep it, use it, hang it up in your office, show it to everybody. Say, HIPAA with 2 P's, that's not me. That's not a thing. Okay, so let's talk about where you do have some confidentiality requirements, right? And that's sort of under, and I love this particular slide that Dr. Schooley has provided. So credit where credit is due. Thank you very much for Dr. Schooley for creating the slide around confidentiality and breaking confidentiality. Because we kind of all know that things are confidential all the time. Like that's important. When you don't give confidentiality or when you have to choose to break it, your authority for doing so is here under Chapter 491 of Florida statutes, and that's the chapter that governs us as therapists. Chapter 39, which again is our abuse, abandonment, neglect statute, where DCF becomes involved. And Chapter 415, which is the statute around adult protective services, when we need to protect at-risk adults. At-risk adult is any person over the age of 18 who's at risk. So adult protective services, we sometimes think about like the very, very elderly or the very, very aged. Adult protective services protects any person over the age of 18 who requires protection. So those could be people who have developmental disabilities or other physical disabilities that require some protection to be put into place. So don't think that it's just the very, very aged or just the people with dementia. It could be anybody over the age of 18, right? Chapter 39 is under 18. Chapter 415 is over 18. So what do we need to know here, right? We need to know about when you need to report. The basic rule of thumb about when you need to report is when you suspect abuse, abandonment, or neglect. Chapter 491 is a little bit more diligent in talking about a clear and immediate probability of physical harm. But again, it's about probability. And you do not have to weigh, gosh, is there more than a 51% chance of this happening? Right? I always tell folks to trust their gut. If you have a gut check and your gut says you need to call, you need to call. You need to call. Better to be safe than sorry. Your anonymity is totally protected. How do I say this? Your anonymity is totally protected. However, you do have to report who you are. If you're licensed under the statutes, you do need to say who you are, your name and your phone number. But the people that you're reporting about will never be told who you are. So I'll give you a good example. Recently, I am involved in a case where, and it's pretty horrific, the child has been Baker acted, and then 90 days later was subject to a Marchman Act. Baker Act is about mental health issues and immediate harm to self or others. Marchman Act is around drug issues and harm to self or others as a result of use of drugs. And in the middle of these two things, I was given access to this child's Snapchat, and her Snapchat was with an unknown male of an unknown age, and the things that they were snapping about were, or he was snapping to her, was a lot of very violent sexual images and imagery, demands that she send naked pictures of herself, which she did. Lots of talk about the things that he was going to do to her of a violent and sexual nature. And I felt like she was being victimized, and I called DCF. I absolutely felt like this is inherently harmful, really dangerous, really bad, really traumatic. This is a child who is fragile at best right now, given the totality of the circumstances. And I don't know if this third person unknown male is in town, not in town, making it up, talking bit, whatever. Just on its face, it's not okay. I had to say who I was. I am the parent's parenting coordinator. So they're involved in huge quantities of litigation, many tens of thousands of dollars. Each of them accuses the other of calling DCF all the time. I don't want to be in the middle of that either. I'm protecting kind of my role as their neutral. And so I made the report, but I am not saying that I made the report. They will never discover that I made the report. And instead, what I did and what you can do is, after I made the report, I received a phone call from a DCF worker, a case, child protective investigator. And so I took the call, obviously, and told that person what I knew or what I believed and all those kinds of things. And then I called the parents and I said, hey, somebody from DCF just called me. Are you guys being contacted from DCF? And so that way everyone's like, oh yeah, I'm being contacted too, but nobody knows who made the initial call. And we're going to keep it that way, right? To protect how these parents are going to co-parent moving forward. It's not helpful if they know that I made the call, but it's helpful that DCF is involved, because I feel like there's going to be a criminal prosecution ultimately. And I think the parents will probably come together around the issue of the damage that's being done to their child by this unknown third party. So do I know with a real probability that this child is in grave risk of danger or harm? Probably not. Did I need to call? Absolutely, yes. That's an easy, right? It's an easy gut check. So if you feel like you need to call, you need to call. Okay, so now we've played around with some of those statutes. And now I want to talk about the case law, because we begin to get into some questions. And certainly, Dr. Schooley, you don't need to share your screen because it's like long and boring. I'm going to talk about the cases, but and the cases are there. There's two cases I want to talk about tonight. One of which is sort of an overarching case in family law, and then one that's hot off the presses that just came out. And oh my goodness, I can't believe everything that went wrong in this case. So there's a question around confidentiality, and there's a question around confidentiality of children because they're children. And in general, what children tell us is confidential in the context of therapy, but not always. Sometimes you're in therapy with the parent and the child. Sometimes the parents consent to finding out what's happening in therapy. Sometimes the parents consent on behalf of the child. And sometimes the parents are involved in protracted child custody litigation, and they want to know what the child is telling the therapist. So the hallmark case around confidentiality of children, that's your governing case beyond the statutes, beyond the rules, is the case of DK. The DK is the child's initials. And DK parents were involved in protracted divorce litigation. And what happened was DK was in therapy and revealed to their therapist that they had been victimized by their father, been sexually abused by their father when they were a young child. And as a result of that disclosure and the therapist telling the mom about that disclosure, the mom filed for divorce and asked for 100% custody, which is a logical move to make. I get that. But then they were involved in protracted custody litigation, and the dad maintained his innocence and said, there's no way, no how, it never happened, and it's lying, you're lying, you just want all my money. And again, that makes sense, right? From the dad's perspective. If in fact nothing happened, then maybe there was this false disclosure. And mom was using this excuse to divorce and try to get 100% custody. It's hard to get to the root of that. Both things could be possible, and we may never know which is true. And during the course of the litigation, both parents consented to have the contents of what DK had told their therapist be shared with the court, with them, with the attorneys, with the guardian, with everyone. And the guardian said, time out. It's confidential. What my client, the child, talks about with their therapist is confidential. You don't get any of that. I don't care that you're the parents and you consent to it. You can't. Confidentiality attaches to minor children as well. And so the case that came out of that is the DK case. It was the first time the courts had taken up the question of whether or not parents can waive confidentiality as it relates to their children. Because, parents and children. And if a parent's consent is needed for a tattoo, or if a parent's consent is needed for school sports, or if parents' consent is needed for marriage under the age of 18, maybe you parents can consent to getting access to their child's information because children are children. So DK addressed the question for the first time in Florida and actually pulled on statutes in Kentucky, statutes in Pennsylvania, statutes in New York, because there'd been nothing written in Florida about it. And DK stood for two things. First of all, the court was really clear in DK. It was a sort of a slam dunk case. DK at the time of the court ruling was 17 years old, and in 5 months was going to be 18. And the court said, duh, by the time you finish your dang divorce, your kid's gonna be 18. It's all protected, and they have the right to assert that confidentiality. The court went further and said, clearly children over the age of 12 have the right to assert their own confidentiality. So what do we know for sure? We know for sure that children over the age of 12 have the right to assert their own confidentiality and say, the confidential experience of my therapy belongs to me. Judges struggle with this Judges would like to hear what's happening in therapy, particularly family law judges. At the end of the day, they do want to know the information. That's where all the good stuff is anyway, right? All the exciting, interesting things happen in therapy with the child. When you're talking about child custody, we get all the interesting bits of information. Everybody wants to know. And it's important for us to be able to explain to judges why the information is confidential. In the event that you find yourself in front of the judge, asserting confidentiality on behalf of your client, the child, the reason why, which we all know, but we need to tell the judges. The reason why is, Your Honor, if you ask me to talk about what happened in therapy, the child will never trust me again. And you will ruin the therapy and the relationship that I and the child have. And it is fundamental and necessary for this child to have a therapeutic relationship. Look what their parents are doing. This child needs a therapist. You need to explain it to the court. They need to know. They don't know. They don't understand. They want the juice. They want the details. They want the interesting bits of information that's going to help them make a good decision. It is not your responsibility to give that information to the court. It is the lawyer's responsibility to find a way to get evidence in front of the court. It is your responsibility to protect your client-therapist relationship with the child. DK says that. DK says that. Okay. So then there was this case that just happened. Hot off the presses. Ridiculously hot off the presses. It became good law on April 27th of this year, because the opinion was released on March 26th, and 30 days later, if it's not appealed, it becomes good law. So here it is. And the case is SHY versus PG. These are the parents, not the children. Those are their initials. This is a case, I want everyone to read it on your own time, in your own leisure, because this is a case where anything that could have gone wrong did go wrong. I'm desperate to find out who the attorneys are on this case. Here's the case. So the parents were already divorced, and they were re-engaging in new litigation around time sharing. And dad was trying to get more time sharing and take time sharing away from mom. And mom was trying to not have that happen or get more time sharing. And they subpoenaed the therapist. Remember subpoenas? We started with subpoenas. They subpoenaed the therapist for a deposition. Therapist hired a lawyer. Good move. Went to deposition. Answered all of the questions at deposition. All of them. Even the ones about confidential information. Some information is not confidential, right? Who brought the child for therapy is not a confidential piece of information. How many times have you seen the child in therapy? It's not a piece of confidential information. What are the clinical issues? It's definitely confidential information. Did the child express a preference about who he or she wanted to live with? Definitely confidential information. The therapist answered all of the questions at deposition. And then there was an emergency hearing around time sharing. The therapist was called on the stand and answered all of the questions. All of them. All of the confidential stuff. Just blew it. And then they went to trial. And at the time of trial, the therapist asserted privilege for the first time. And said, oh, I can't talk about that. That's confidential. And ultimately, the appellate court said, yeah, You can't say it's confidential after the fact. Once the horse has left the barn, it's no longer confidential. You blew it. There's no doubt in my mind that this therapist just blew through chapter 491, blew through all of the statutes. I hope this therapist has a, good attorney, good malpractice carrier. I'm not sure quite, how it's going to wind up. The only other thing that happened in this case that's important is the appellate court ruled that any confidential information that wasn't already disclosed, that can stay confidential. So you can't ask the therapist to go further than they've already gone by saying, oh, well, you've destroyed all confidentiality completely, so now you can say anything you want, or we can compel you to say anything you want. But anything you said, you can't put the toothpaste back in the tube. And so part of what's really important for you to think about as practitioners of therapy is getting ahead of that curve, which is part of why we talked about all those shields at the beginning, because your responsibility is not to the court. Your responsibility is not to the lawyers. Your responsibility is to your client, and your responsibility is to protect your client's confidentiality, because also, as you all know, confidentiality doesn't belong to you, it belongs to your client. It belongs to your client. And so you get to assert it, and unless or until they waive it, you don't get to do so. This therapist was 6 ways from Sunday doing everything wrong here, which appalled me. And so I wanted everyone to be aware of it, right? We're still not getting it right. I'm really sad that it's here, but I'm glad that we're able to use it as a teaching tool, right? Okay. So I also included sort of at the end of the documents here is I call it a vocabulary worksheet or whatever, a term glossary. I put some things here. We can use it as a working guide also. I'm happy to talk about what some of these things mean and why they're important for us to know just as working terms. But I'm also happy to answer any and all questions that anyone has. All right, so let's take a look at these first, just for fun. So a subpoena ducis tecum is the first term that we actually talked about today, which is right, that subpoena that you get. A ducis tecum means they're going to ask you questions, go on that fishing expedition. And if it says without deposition, that means they just want you to produce some documents. So that's what a subpoena ducis tecum is. A suggestion of incapacity is something that gets filed in a case when someone's mental health has been determined to be incompatible with daily life, daily productive living. You might see that as a CGAS score, a really low score, or a GAF of a really low score. You see it a lot for cases with adults who maybe have dementia, who can no longer care for themselves or do their own bank accounting or any of those kinds of things. Sometimes you'll see it in cases where there's a criminal component involved, right? Someone might be declared criminally insane. A suggestion of incapacity is a document that's filed when somebody can no longer adequately assist counsel in their own representation. What a suggestion of incapacity does is it immediately tolls the case, puts the brakes on of any case. It puts the brake on a criminal case. It puts the brakes on a civil case. It puts the brakes on a family case. All cases, this puts the brakes on. And the reason why we do that, again, is a policy reason in Florida. And the policy reason is because we don't sue people who lack mental capacity. They lack mental capacity. And it's not right to try to sue someone or progress a lawsuit against someone who doesn't have capacity. So if you ever see a suggestion of incapacity or someone says, oh, we're filing a suggestion of incapacity, what it does is it literally puts the brakes on the case. In a divorce case, it puts the brakes on for 24 months, after which somebody is presumably appointed to represent the best interest of the incapacitated person, or the person has regained capacity and they're able to move forward with their lawsuit. So that's what that is. The disability of non-age is the fancy way of saying a child's been emancipated. We remove the disability of non-age. I put that in there because it's referenced in the DK case and in the SHY case. And we do in Florida make some special circumstances and some exceptions for children who have demonstrated the ability to be mature and be responsible and live as adults. And so we remove the disability of non-age, and they can enter into contracts, and they can have jobs, and they can live on their own, and we don't have to worry about truancy or any of those kinds of things because we've removed the disability of non-age.
Rebecca, so
Yes,
the disability of non-age is automatically removed when the child becomes 18?
yes. At which point, if you have a child who is over the age of 18, or if you have a person who is over the age of 18, but cannot adequately care for themselves, let's say due to a developmental disability of some nature, then they need to have a guardianship placed over them.
And now we're into suggestion of incapacity land.
Now you're into suggestion of incapacity land, yes. Many parents of special needs children who will not ever regain or will not ever have capacity do some really good planning ahead of time and file the guardianship or have the guardianship papers ready to go at the moment of the child's 18th birthday, so that they can have transition. Because if you have a child who's over the age of, if you have a person who's over the age of 18 and as yet has not been found to be incapacitated, then their caregivers can no longer provide care for them. Like their parents can no longer consent. So for instance, I have a friend who has a child who has got a fairly significant, for lack of a better word, case of autism. Their child is nonverbal. Their child, doesn't toilet. Their child is 19 years old and occasionally suffers from seizures. When their child turned 18, if their child had a seizure and had to go to the hospital, their parents couldn't consent to any care, but neither could that child. And so they had to file guardianship paperwork to protect their child so that they could continue to consent to care. So that's, you have to move from one to the next, if that makes sense.
It does.
Okay. So sovereign citizen is a relatively new phenomenon. Thanks very much to the last 6-8 years of politics. It is a very political term. A sovereign citizen is a person who declares themselves to be their own sovereign and therefore non-participatory in the laws and statutes of the place where they live. It is loosely based on the Indian Protection Act and the treaties that Native peoples have with our country. We live in Florida, so many of us are familiar with the Seminole Nation, and that when you cross onto lands held by the Seminole tribe of Florida, you are subject to the rules and the laws of the Seminole people. And they are a sovereign nation, and we recognize them as a sovereign nation. A sovereign citizen thinks that they're their own person under the same theory. It holds exactly 0 legal weight. But they will make these statements and they will make these assertions and they will tell you that they are a sovereign citizen. It makes me wonder about their capacity.
So it's over there in the same statute with HIPAA with 2 Ps.
Yeah, that's exactly where it lies, right? In pretend world. If you ask someone, and I have done this as an attorney, I've said, well, what's your authority for sovereign citizenry? Generally, it's Facebook, which is not legal authority. So I'm just letting you know that it's a thing that exists. Most attorneys that I know are pulling their hair out over sovereign citizens. I'm going to skip hearsay and come back to it because it's a big concept, and I do want to take some time to talk about it now because that will preview us for next time. A party is a person whose name appears at the top of the caption for the lawsuit. Mr. Smith versus Mrs. Smith, those are the parties. Unless you are suing or being sued, you are not a party. You are a non-party. And if you remember the stuff we talked about, section, Florida Rule of Civil Procedure 1.350, it referenced non-parties. That's you. The only time you would be a party to the action is if you're a guardian. Guardians are parties to parents' divorce cases because they advocate for children. Children are not parties. Children are never parties to their parents' divorce cases, even though it may be 100% about them. Children are never parties, but their guardians are. We don't say plaintiff and defendant in Florida. We don't in family cases. We say petitioner and respondent. So that's who it is. It doesn't matter whether you file first or second for a divorce case, a paternity case, it makes no difference. But the person who files is the petitioner and the person who answers is the respondent. And then frequently the lawyers get excited and they file cross petitions and cross responses. And so you have a petitioner / counter respondent, and then you have a respondent / counter petitioner. It gets very confusing very quickly. I always recommend using mom and dad as my reference names. Though that's beginning to get a little bit more complicated because now we have parents. And Florida is a little bit cutting edge in terms of, oh, somebody's saying goodbye. Bye, Ari. So Florida's getting a little bit more cutting edge regarding parenting and two-parent homes where both parents may identify as the same gender, and parenting homes where one parent may identify as a gender that is neither male nor female. And so as you begin to think about your language, you might need to think about what word I want to use. Certainly petitioner and respondent are gender neutral, but you have to make sure you remember who is who. So that's about that. And then I want to talk for a minute about hearsay because that moves us into our conversation next time, which is the most common objection in court and in deposition is objection hearsay, which you may or may not have heard on television or may or may not have heard in a courtroom setting yourself. Hearsay is a relatively simple legal concept, but comes with lots of exceptions. And that's why people get confused. People don't get confused about hearsay, they get confused about the exceptions. Hearsay is an out-of-court statement offered for the truth of the matter asserted. I'll say it again. Hearsay is an out-of-court statement offered for the truth of the matter asserted. So, Dr. Schooley, if you'll stop sharing screen, I'll give a good example. But that way I'm bigger and I can see other people's responses. So, if Dr. Schooley and I are having lunch and Dr. Schooley says, oh, I really love chocolate. My favorite food to eat is chocolate. And now we're going to court and I have to testify about something Dr. Schooley said. And Dr. Schooley is trying to prove that they hate chocolate. Chocolate's disgusting. They're trying to prove that they would never eat chocolate. And I'm being asked, has Dr. Schooley ever told you anything about chocolate and whether or not they like chocolate? And I say, well, actually, yes, Dr. Schooley told me. And the lawyer's going to stand up and go, objection, hearsay. Because what I'm about to testify to is an out-of-court statement, because Dr. Schooley and I were not in court at the time. And I'm about to prove something about Dr. Schooley's opinion on chocolate. So the truth of the matter asserted. If Dr. Schooley's case was about whether or not she liked mangoes, and I'm going to talk about chocolate, that's an exception because it's not going to the truth of the matter asserted. A chocolate conversation has nothing to do with mangoes. It's just being offered to prove that I had lunch with Dr. Schooley, but maybe not being offered to prove anything about chocolate or mangoes. I might be asked, did Dr. Schooley have a mango salad? That's something I observed. That's not something Dr. Schooley said. I can testify to that. That's not hearsay. So, the general rule of thumb, whenever you hear somebody say objection, hearsay, is to wait until someone can tell you whether or not you're supposed to answer. And the other general rule is never talk about things that were said outside of court. If it was not said in a courtroom, don't testify to it. Which means, ipso facto, every single thing your client tells you in session is hearsay. Because you don't have a single session in the courtroom. It's all hearsay. All hearsay. It's all objectionable. Never mind that it's confidential. It's all objectionable. The devil, of course, is in the details. It's all the exceptions. Because there's lots of stuff that you can get in, that the lawyers can get in, as making an exception. For instance, a child who makes a disclosure about sexual assault, that's an exception. And then there are a lot of exceptions. But in general, anything that you're going to talk about that somebody said to you, you can't talk about it. So you have another layer, another shield to protect your client's confidentiality. So let's talk for a second again, just for fun. Remember the Kardashians? Let's just talk about them for a second. When we think about what are the sorts of things we may or may not be able to talk about. If you get a subpoena for records, what are the sorts of documents you may or may not be able to share? Right? Can you share, or can you create a memo that you share about how often they came and on what dates? Possibly. Right? Probably. Can you talk about what was said in session? Probably not. That's going to be confidential. Can you talk about or discuss anything you may have documented in the file regarding observations you made in the waiting room? Maybe. Didn't happen in clinical session. So maybe you can, right? Maybe you saw the older child saying, I'm going to leave you just like daddy. That might be important. That might be the kind of thing they want to know about. This is a custody battle, right? Kim's going to want to show that Kanye leaving was detrimental to the children. Maybe the little one said, I hate you, mommy, while they were in the waiting room. Maybe Kanye wants to put that in and get you to testify to that to show that the children should be with him.
So, Rebecca, if the children say something, I'm thinking that falls under hearsay. But if they are playing with dolls and they have the dolls say that, I've observed this behavior of one doll beating up the other doll, and I observed that from what you're saying is not hearsay, and it's not happening in the session. So that I probably could attest to.
So there's two things to think about when we begin to think about hearsay and testifying and documentation, maybe more than two things. If you're looking at just the the subpoena ducis tecum without deposition, where they're just looking for documents, right? The question about hearsay has not arisen yet because you're not in front of a judge, so it doesn't matter if it's hearsay or not.
Okay.
You don't have to, you certainly don't have to think about that. That's for the lawyers and the judges to figure out, not you. So anything that you overheard, any language you may have written down that a child said, that a parent said, that maybe you made a note of that outside in the waiting room, so it's not confidential, but you thought it was important, that may be something you produce. Whether, right, a statement may be something you produce, right? Child said, I hate mommy, before coming into session. Anything you observe is not hearsay. As a guardian, I spend a lot of time, because I have to write a report, and so I spend a lot of time observing the children's behavior and then writing about what I've observed, so the judge can hear about it, because it's not hearsay.
And
Now,
it's not confidential.
As a guardian, the things that I do with the children is not confidential. The therapist records, so I'm the guardian for these children, and I call you, Dr. Schooling, and go, hey, I'm the guardian. I'd like to talk to you about what you're learning with the children, your clinical experience, what you think, da 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 da. You, as the therapist, actually get to tell me everything as the guardian, and you're not breaking confidentiality. You are passing the confidentiality ball to me, and I am required to hold it. So the guardian has a very interesting position, because the guardian becomes the holder of confidential information, which helps me shape my suggestions and recommendations to the court. But I get to keep the confidential information, and I get to keep it, and I'm required to keep it confidential. And I gave you guys the statute on that earlier. The 61404 talks about how the guardian holds confidential information confidential. I get DCF records all the time. They're confidential. I talk to therapists all the time. They're confidential. What do you do as the therapist to protect yourself and protect your own file? Because that's really the question you all want to know the answer to. When I call you and I say, hi, Dr. Schooley, I'm Rebecca. I'm the guardian for the minor child so-and-so. I understand you're seeing them in therapy. And you plausibly deny, I can neither confirm nor deny that I see the child. That's the right step. I say, not a problem. I'm going to send you the order appointing me the guardian. And you're going to look at the order, and the orders contain in them, the person to whom this order is directed shall distribute and disseminate any and all information. So now you, as the therapist, are under a court order to give me, the guardian, the goods. All of the goods. Because that confidentiality passes to me. It's my responsibility now to hold it. You have done nothing wrong by telling me everything.
Is there any other person that a court order can compel a therapist to break confidentiality other than a guardian?
It's an interesting question.
Because from what you're telling me, if I'm in court, there is no guardian, then it's my job to keep it confidential.
Correct.
But I suppose from the bench, the judge could order me to answer.
Right.
That could happen.
So the next shield in your line of defenses, and I am not afraid of
this is where I say, but Your Honor, if I answer that in front of the parents, the therapy process will be undermined, and right. So that's where I say that.
And the judge says, I don't care, Dr. Schooley, you need to tell us. And you can say, Your Honor, I'm not going to do it.
Ooh.
Right? You could say that. Right? They are not God. They're just judges. I've met a bunch of them. I'm smarter than a lot of them.
This is the other reason why I have my attorney, because my attorney should object.
100% correct, right? You should have an attorney. Your attorney should object. You're on it. You got it, right? And the judge is going to issue a written order compelling you to testify. And what is your lawyer going to do? They're going to appeal it. You're going to buy yourself some time.
Got it. Irma's got her hand raised.
Yes.
So in all of this, I'm thinking privileged communication in the sense that I cannot disclose information that has been privileged to me. So I'm holding it. So I can do that with a child, with a minor. I can do that actually even in couples therapy, unless I have a waiver, which is very dangerous to see each person separate. So I'm not thinking necessarily confidentiality, but that this information is privileged. So when the records are subpoenaed, I have to be also very mindful that I don't release communication that has been privileged.
100% correct.
Okay. I just want to be clear because I'm hearing a lot of confidentiality, and in my mind, I am thinking privileged communication.
Well, but Irma, in our chapter 491, the word privilege does not appear, because privilege is the language that we talk about attorneys and clergy having, and Meredith can speak to that, and Rebecca can speak to the attorney. Therapists do not have privilege. Clients have privilege.
Correct. Yes, of course. It's the privileged communication that the client.
But they own the privilege. Is that?
Of course,
is that
they
not
own
right?
the privilege. Yes,
right.
Of course. Yeah, they own the privilege. I'm sorry, I misspoke.
Yeah.
A good way to think about it is if you're a secret keeper, you keep the secret.
Correct.
Right. That's my blanket rule. Secret keeper.
Right.
And in fact, when I'm the guardian ad litem for children, which is always what I am, I tell them that I'm their secret keeper, because that's something they can understand. Right. I say, my responsibility is to be your secret keeper. And unless I have to tell somebody, I'm not going to tell anybody anything. And the other thing I always tell children, because I think this is a good practice, is nobody can get in trouble with me. You can't get your mom in trouble. You can't get your dad in trouble. Nobody can get in trouble. Anything you tell me, nobody gets in trouble. And that seems to be a good bridging system for me.
But the guardian also has to break confidentiality, though, in the case of child abuse.
Yes.
Yeah. So that's one secret that cannot be kept. But other than that, right. And that's very similar to therapists. So guardian ad litems cannot be compelled to provide information, but therapists can be compelled.
So they will try to compel guardians. Goodness knows they've tried. And I haven't yet seen a case where the guardian was required to do it. I've seen some stuff come up on appeal where they've tried and the court has ruled nope. It's confidential.
Okay, and is that true also for therapists, that if therapists assert the privilege on behalf of their client, and then the court tries to compel it, and then that on appeal therapists cannot be compelled?
So I've seen a little bit less of that. I have seen some therapists be compelled, and the reason why it was compelled was the court determined that the party had waived the privilege. So let me give you an example of how that works. So there's a case with a mom and a dad, and they're fighting over custody, and dad says mom's crazy, she's bipolar, she's doesn't take her meds, and mom splashes into that water and says, I might be bipolar, but I'm totally under control and everything's fine and I'm not a danger. So the mom has now put her own mental health at issue. It's now a question for the court to consider because she splashed back into that little pool.
Now this is she's splashed in the pool in therapy.
No. Dad said, my wife is crazy.
This is in court.
Right. Dad filed his divorce and said, I should give 100% custody, judge, because my wife is nuts.
Oh, so because in court, she essentially affirmed that, yes, I'm bipolar, then a therapist could be compelled to talk about what they know about her bipolar?
Could be compelled to talk about what they know about her bipolar. And what she said is, I'm bipolar. I don't have to take my meds. Like she puts this in the court document. I'm
Gotcha.
bipolar.
This is Kim and Kanye. Only it's Kanye with the bipolar and
Kanye saying, yeah. I'm bipolar. I don't have to take my meds. I'm totally safe around the children. Puts it in a document that the judge reads. Well, now the court has to make a determination. Is Kanye bipolar? Does Kanye need meds? Is Kanye safe around the children? Who's going to be able to talk about that? Kanye's therapist. Kanye did the waiving of the privilege.
Gotcha.
Putting it in front of the judge. If Kanye said, right, my mental health diagnosis, if any, has nothing to do with nothing, now the court can't do anything with it. But if you put it in a document that the judge is going to read, you opened the door.
Gotcha. But this is again where the therapist's attorney will help the therapist know if that's where we are.
Right.
Okay.
I always recommend when you get served with a court document, have somebody with a bar license take a look at it and tell you what you can and can't do or should or shouldn't do and that you should not panic. It's always nice to call an attorney. He goes, you got served, don't panic. Because then you don't panic, right? And I always recommend do not go to a deposition naked. Do not allow somebody to ask you questions without your attorney present, who understands the rules, who understands hearsay and the exceptions and the whatever. This is a truth of my own life. I have an attorney on retainer as the guardian. And when they begin to depose me or send me subpoenas, then my attorney steps right in and files stuff on my behalf. Even though I know the rules, right? And you know this, right? It's the same thing that like if you're involved in a family issue in your own, like you can't self-therapy your way out of your own stuff in your life. As an attorney, you can't self-represent your way out of your own stuff. So I practice what I preach. So don't go naked to a deposition. Don't go naked to court. Always, have an attorney with you to object on your own behalf, to assert privilege when you forgot that you might have it. Attorneys are sneaky little jerks. We'll talk about this next time, but attorneys are sneaky little jerks. They'll try to be your friend and get you to agree to stuff on the stand.
It apparently that's what happened in SHY. Yeah.
I do not know who the therapist attorney was, but man. And the other thing to think about is when you think about like what kind of attorney do you want to have, it may be worth it to find a malpractice attorney, someone who really does specialize in Chapter 491 stuff, because that's going to help protect your licensure. If it's a family case, maybe you want a family attorney who understands those rules of the road. So my recommendation probably is if it's a civil case, you want a Chapter 491 malpractice attorney, because general civil litigation is general civil litigation, and malpractice attorneys speak those rules. If it's a family case, you probably want a family law attorney, because that's someone that speaks those rules. They're a little bit different.
Good to know. Well, I'm looking at the time.
Mm-hmm.
These 2 hours went by very, very quickly. So I appreciate that very, very much. And so I appreciate that, Rebecca. We're going to stop the recording now.
Sure.